Law enforcement officers are required to provide Miranda warnings before interrogating an individual in custody. In some situations, a person who isn't in custody is still entitled to Miranda warnings if officers' behavior indicates the individual is neither free to leave nor free to refuse to answer questions. But what if an individual agrees to an interview because he doesn't realize he's the subject of a criminal investigation? Does that misunderstanding entitle a person to Miranda warnings? The Supreme Court considered this question in Beckwith v. United States. While investigating Alvin Beckwith for suspected tax fraud, two Internal Revenue Service agents visited Beckwith at a private residence where he was staying. The agents introduced themselves, explained that one of their functions was to investigate tax fraud, and informed Beckwith that they had been investigating his tax liability. One of the agents read from a card stating that under the Fifth Amendment, they couldn't compel Beckwith to answer questions or incriminate himself. The card further stated that anything Beckwith said or any information he provided could be used against him in a criminal proceeding and that he could consult an attorney before responding. Beckwith acknowledged that he understood his rights and agreed to the interview. He answered the agent's questions and, at their request, provided records discussed during the interview. When Beckwith was prosecuted for attempted tax evasion, he moved to suppress his interview statements and the evidence derived from those statements. Beckwith argued that before questioning, the agents were required to provide the specific warnings established in Miranda v. Arizona. The district court denied the motion, and Beckwith was convicted. On appeal, the D.C. Circuit affirmed his conviction. The Supreme Court granted cert.